Imagine you're at a bustling public gathering, maybe a protest, a vibrant festival, or even just a massive crowd, and suddenly things start to get out of hand.
Yeah,
That invisible line between a lawful assembly and something that could quickly escalate into a riot, well, it's incredibly thin, isn't it?
it really is. It can change in an instant.
Or let's consider the less visible but equally vital gears of government. How absolutely crucial is it that the public servants behind those gears act with unwavering integrity, without fear or favor?
Fundamentally important. Trust is everything there.
Welcome to the deep dive. Today, we're taking a truly fascinating look into the Bhartiya Nyaya Sanhita 2023, or BNS 2023 for short, India's groundbreaking new criminal code.
It's a major shift.
We've got a stack of crucial sections, everything from preventing public disturbances and addressing the insidious nature of hate speech to ensuring the integrity of public servants and the justice system itself.
It covers a lot of ground.
Our mission today is to really unpack these foundational laws, reveal their core objectives, and show you how they impact your daily life, your civic duties, and, well, the very fabric of society.
Think of this as your shortcut to understanding the legal pillars that uphold peace and trust, and some of the surprising shifts in legal thinking.
Exactly. And this deep dive isn't just about understanding a new set of rules, is it?
No, not at all. We'll explore how these laws aren't merely about punishment, but about something called preventive justice, aiming to, nip potential problems in the bud.
Right, stop things before they escalate.
Exactly. And ensure accountability at every level and protect the foundational principles of a functioning society. You'll gain insights into the deeper why behind these legal distinctions.
And the often surprising ways they shape our collective responsibilities.
Right. It's about building a framework for a more just and orderly society, with a modern lens on some pretty ancient challenges. So let's jump right into that first pillar. How the BNS 2023 works to safeguard public tranquility. This begins right at the heart of how groups gather, how quickly things can escalate, and the profound legal implications of collective action. What differentiates a benign crowd from a potential problem?
Okay, so when does a simple crowd, perhaps even a spirited demonstration, transform into something legally problematic, specifically an unlawful assembly? Section 189 BNS gives us the definition, and it's far more nuanced than just, large group of people.
That's right. The core concept here is that an assembly of 5 or more persons becomes unlawful, not just because of its size, but because of its shared goal.
The shared goal?
Yes, what the law calls its common object. This common object must fall into one of 5 very specific categories of illegality.
Okay.
It's fundamentally about why the group is together, not just that they are together. And that distinction is crucial for protecting legitimate assembly while preventing misuse.
Okay, let's unpack those 5 whys then. What are the main intentions that cross that line? Well, broadly, they cover scenarios where a group aims to undermine authority, resist the law, commit other crimes, seize property or rights by force, or coerce others.
Right.
For instance, the first and perhaps most significant is using force, or even just the show of criminal force, to intimidate or overpower the government or any public servant performing their lawful duty.
So like trying to physically stop an official?
Exactly. Imagine a group of, say, 7 people trying to physically prevent a municipal officer from carrying out a lawful demolition order.
Okay.
That immediately transforms a gathering into an unlawful assembly because their common object is to overawe authority through force or the threat of force.
Right. Trying to use intimidation to bend the will of authority. Got it. What else makes a group's purpose unlawful?
Another crucial common object is directly resisting the execution of any law or official legal procedure.
Like stopping an arrest.
Precisely. Stopping an arrest, blocking the execution of a court order. It covers anything that hinders the implementation of law. It's about maintaining the fundamental rule of law.
Makes sense.
And of course, if the group's shared goal is simply to commit any crime, whether it's damaging property like mischief, or illegally entering someone's land, criminal trespass, or any other offense.
Then the assembly itself is unlawful from the start.
Yes. Think of 10 individuals gathering, maybe armed with sticks, with the clear intent to illegally enter a disputed piece of land and claim it. Their common object is criminal trespass, making the assembly unlawful.
Okay. And what if a group tries to take property or deny someone their rights by force? Is that covered too?
That's another key category, using criminal force to take property or to deny someone their right of way or maybe use of water or other intangible rights they possess. It also covers enforcing a supposed right through force.
So no vigilante land grabbing, essentially.
Exactly. This protects individuals from collective strong-arm tactics aimed at seizing property or rights outside legal channels. You can't just enforce what you think is your right by force.
And the last one.
The final category is using criminal force to compel someone to do something they are not legally obligated to do, or to prevent them from doing something they are legally entitled to do.
Protecting individual freedom from group pressure.
Yes, it's about protecting individual autonomy from collective coercion.
What seems really significant here is the dynamic nature you mentioned. An assembly doesn't have to start out unlawful.
That's a very important nuance.
It can become one subsequently if its members develop one of these common unlawful objects.
Precisely. It highlights the fluid nature of group dynamics. A peaceful protest could, unfortunately, turn unlawful if the group's objective shifts midstream to, say, resisting police orders forcefully.
That asks a lot of individuals in the group to be aware of that shift.
It does. It asks us to be mindful of how a gathering can evolve and what the group's current objective is.
And the penalties for just being a member, they seem quite significant.
They are. Basic membership, just being aware of the unlawful nature and intentionally joining or continuing in it, can lead to up to 6 months imprisonment, a fine, or both.
Okay.
But the stakes go up considerably if you join or continue in an unlawful assembly after it's been lawfully commanded to disperse. That can extend to 2 years imprisonment, a fine, or both.
Emphasizing respecting authorities' attempts to restore order.
Absolutely. And being a member while armed with a deadly weapon or anything likely to cause death when used as a weapon also carries that potential 2-year sentence. It recognizes the increased danger.
Right.
Furthermore, and this is quite important, the law extends accountability to those who hire or harbor members for unlawful assemblies.
So the people behind the scenes.
Yes, they're punished as if they were members themselves and can even be held responsible for offenses committed by the hired persons. It's a deliberate attempt to cut off the supply chain of collective illegality.
So for you, the listener, listening right now, what's the most important takeaway here from Section 189?
I'd say this section is a classic example of preventive justice. It's designed to nip potential collective violence or illegality in the bud by deterring the formation of groups with dangerous intentions.
It's a warning sign.
It is. It fundamentally asks you to be mindful of the company you keep and the shared objectives of any group you join, reminding us that collective action carries collective responsibility. It's really about proactive deterrence against mob rule.
Okay. Building on that idea of collective responsibility, Section 190 BNS takes it a step further, and this is where I think the law casts a surprisingly wide net. If one member of an unlawful assembly commits a crime, are all members held accountable, even if they didn't directly participate?
This is where it gets really interesting, and it represents a powerful shift in accountability. Section 190 introduces the concept of vicarious liability, or you might call it constructive liability.
Meaning you're liable for someone else's actions?
In a sense, yes.
Yeah.
If an offense is committed by any member of an unlawful assembly in prosecution of the common object of that assembly.
Okay, so related to the main goal.
Right. Or if it's an offense that the members knew to be likely to be committed in pursuit of that object.
Knew to be likely.
Then every single person who is a member of that assembly at that time is guilty of that offense.
So it's not just about what you did, but what the group as a whole might foreseeably do. That feels like a significant expansion of liability.
Precisely. There are two crucial limbs or parts to this liability. First, the act must be directly related to achieving the group's unlawful goal in prosecution of the common object.
Makes sense.
But the second limb significantly widens the net if the members knew to be likely to be committed.
Yeah.
This doesn't mean you specifically intended that particular crime to happen.
Right.
But if a reasonable person in that situation, in that assembly, would know it was a likely consequence of pursuing the group's common object, then you're on the hook.
That's a huge distinction compared to concepts like common intention, which usually demand a prior agreement, a meeting of minds.
Absolutely.
This implies a more fluid, maybe on-the-spot assessment of risk, doesn't it?
It does. Unlike common intention, which typically requires that prior meeting of minds and concerted action, the common object under this section can actually develop on the spot.
Right.
It can evolve with the assembly's actions. This makes the provision much more adaptable to the fluid, sometimes spontaneous, nature of group behavior and the potential for rapid escalation we talked about.
Okay, let's try a concrete example. If an unlawful assembly forms to, say, commit theft from a shop,
Okay.
and during the theft, one member assaults the shopkeeper to help them escape, Are all the members potentially liable for that assault?
Most likely, yes. Under Section 190, all members could be liable for the assault if it was known to be a likely consequence of committing theft in that particular manner, even if their original common object was just the theft itself.
Even if they just wanted the goods?
Right. Because violence is often foreseeable during a forceful theft. However, contrast that. If the common object was only a peaceful, though still unlawful, protest, and one member suddenly and unpredictably attacks someone completely unrelated to the protest's goal, then others might not be liable if that attack wasn't connected to the common object or wasn't a foreseeable outcome of that specific protest. The key is that collective foresight, that knowledge of likelihood.
What's the big takeaway for our listeners here from Section 190? It seems quite profound.
I think this isn't just about punishment. It's a really brilliant piece of legal engineering designed to dismantle mob mentality at its very root.
How so?
It forces every individual in a group to think twice about the potential outcomes, not just their own direct actions. It fundamentally shifts accountability from purely individual intent to a kind of collective foresight.
So what might happen if we do this becomes everyone's responsibility?
Exactly. That's a powerful leap in preventive justice and a very strong reminder that when you join a group with an unlawful object, you share in its foreseeable liabilities. Think before you join.
From the formation of unlawful assemblies, things can, unfortunately, escalate to physical violence.
Yes, sadly.
This brings us to rioting, under Section 191, and also the often overlooked act of inciting such violence, which is Section 192.
So, when an unlawful assembly crosses that critical line from merely intending illegal acts to actually using force or violence,
That's the trigger.
that's when it transforms into a riot.
Mm.
The core concept of Section 191 is essentially that rioting is an aggravated form of unlawful assembly. It happens, and I quote, "whenever force or violence is used by an unlawful assembly or by any member thereof in prosecution of the common object of such assembly."
So the key differentiator is the actual physical use of force or violence.
Yes, that's the defining element.
So it's the moment the potential for harm we discussed in unlawful assembly turns into actual harm. That seems like a very clear legal transition.
Indeed. Think of it as the unlawful assembly moving into a dangerous active phase. The moment that force or violence is used to achieve the group's illegal aims, every member of that assembly can potentially be guilty of rioting.
Even if they weren't the one throwing the first punch, so to speak.
Yes. Because of that collective responsibility under Section 190 we just discussed, if the common object was unlawful and force is used in pursuing it, everyone who was part of that assembly at that time could be liable for rioting.
Like the example you gave earlier, the group gathered to illegally demolish a structure.
Exactly. If they start using crowbars and hammers and forcibly resist people trying to stop them, all members instantly become guilty of rioting. The use of force transforms the situation legally.
And what about the severity of the punishment, especially if weapons are involved? Does the law make distinctions there?
Oh, absolutely. The law takes this very seriously. If you're found guilty of rioting while armed with a deadly weapon or anything likely to cause death when used as a weapon,
Okay.
the punishment jumps significantly, while general rioting can lead to imprisonment for up to 2 years.
Which is already serious.
Right. Armed rioting carries a maximum of 5 years imprisonment plus a fine. This recognizes the heightened danger posed by armed groups and sends a very clear message about the state's resolve to curb such violence.
What's the crucial takeaway from this section for maintaining public order? Why is this distinction so important?
Well, this section is about addressing direct and serious breaches of public tranquility. It tells us that while merely intending to do harm as part of a group is bad,
As we saw with unlawful assembly.
right, actually doing harm with the group has far more severe consequences. It's a direct response to collective violence, drawing a very clear line in the sand between potential and actual disorder.
Okay, beyond the participants in a riot, there are often those who deliberately stir the pot, right? The instigators. Section 192 BNS targets these individuals who might not even be physically present in the riot, but could be responsible for igniting it.
That's a really important aspect. Section 192 focuses on those who, and the language is specific, malignantly or wantonly by doing anything which is illegal, gives provocation to any person intending or knowing it to be likely that such provocation will cause the offense of rioting to be committed.
Malignantly or wantonly. So with ill intent or reckless disregard.
Exactly. It's about a blameworthy state of mind combined with an illegal action designed to ignite violence.
So it's not simply about saying something controversial or unpopular. The provocation itself must stem from an illegal act.
Precisely. The law is looking for an illegal act as provocation, not just words alone, however offensive they might be. This illegal act must be done malignantly or wantonly, meaning with malice, ill will, or that reckless disregard for the consequences.
Okay.
And crucially, the provocateur must specifically intend the provocation to cause a riot, or at least know that a riot is a likely outcome. It's quite a high bar for proving that criminal intent.
And how are these instigators punished? Does it depend on whether a riot actually breaks out as a result?
Yes, there's a graded punishment based on the outcome. If rioting is committed in consequence of such provocation, the punishment can be up to 1 year imprisonment, a fine, or both.
Okay.
However, even if rioting is not committed, the dangerous intent and the illegal act are still recognized. In that case, the punishment can extend to 6 months imprisonment, a fine, or both.
So the law punishes the attempt to ignite the fire, even if it doesn't fully catch.
Exactly. It recognizes the inherent danger in such provocative illegal acts, regardless of the final outcome.
Can you maybe paint a picture for us with an illustrative scenario? How might this play out?
Sure. Consider someone who illegally desecrates a place of worship. If they do this with the malicious intent of provoking one religious group to riot against another, that's a clear example.
Right.
Or someone wantonly spreads a completely false and illegal rumor, maybe, about a violent attack on their community, knowing full well it's likely to cause members of their community to riot in retaliation.
Okay, that makes it clear. These are exactly the kinds of scenarios the section aims to prevent.
Yes. It highlights the profound legal consequences of using illegal acts specifically to stir up trouble and potentially incite mass violence.
What's the broader significance of Section 192 for our society? Why is it so important to have this?
This section is crucial for deterring acts of incitement that can lead to widespread public disorder and violence. It holds those who fan the flames accountable, even if they don't directly participate in the ensuing riot themselves.
It targets the root cause, in a way.
It does. It highlights the serious legal consequences of using illegal acts to stir up trouble and endanger public peace. It tries to strike that delicate balance between, say, freedom of expression and the absolute imperative of maintaining social harmony and preventing violence.
Now, let's broaden our view beyond just the direct participants and instigators. What about others who might be indirectly involved, like people who own the land where disturbances happen, or maybe smaller public brawls, or even those whose job it is to protect us? The law seems to extend responsibility in some surprising ways here.
This is a fascinating aspect of preventative justice, actually. Section 193 essentially enlists property holders as active partners in maintaining public order.
Partners, how so?
The core concept is that owners, occupiers, or anyone with an interest in land, and this includes their agents or managers, have a direct responsibility to prevent unlawful assemblies or riots from taking place on their property.
So it's not enough to just be unaware or passive if something's brewing on your land. There's a proactive duty here.
Absolutely. You're liable to a fine. The section mentions up to €1 if you, your agent or manager, knew or had reason to believe an offense like unlawful assembly or rioting was happening, had happened, or was likely to happen.
Okay.
And you failed to give the earliest possible notice to the nearest police station.
Right. A duty to report.
Yes, and there's more. If you believed it was about to happen, you must use all lawful means at your disposal to try and prevent it.
Actively present it.
Yes. And if it already took place, you must use all lawful means to try and disperse or suppress it. It's quite a significant civic responsibility tied to property ownership or control.
That seems like a high bar. What if, hypothetically, a riot occurred that actually benefited the landowner? Say, in a land dispute. Is there a stronger onus in that case?
Yes, the law anticipates that. It imposes an even greater onus if the riot occurs for the benefit or on behalf of the landowner-occupier or someone claiming an interest in the land, or if it relates to the dispute that caused the riot, or if someone derived a benefit from it.
Okay.
In those cases, such persons and their agents or managers are punishable with a fine if they fail to prevent or suppress the disturbance after having reason to believe it was likely.
The implication being you can't profit from disorder on your land while turning a blind eye.
Precisely. You can't just let it happen if it serves your interests.
For our listeners, especially property owners, what's the crucial takeaway from this section?
Well, this section fundamentally changes the expectation for property holders. It penalizes their negligence or willful inaction, ensuring that private property isn't just misused as a venue for large-scale public disturbances.
It makes property owners responsible for public order on their property.
In a way, yes. It raises an important question for all of us. What are our civic responsibilities when our private spaces might become arenas for public disorder, and how far does that responsibility extend? It highlights that private property doesn't always mean private problems when public peace is at stake.
Okay, moving from potentially large-scale disturbances, there's also the issue of the simpler public brawl, often less severe, maybe, but still disruptive. This is where Section 194 BNS, dealing with a fray, comes in. What's the core idea here?
A fray is really about maintaining public decorum and peace. The core concept is a breach of public peace caused when two or more persons, by fighting in a public place, disturb the public peace.
So it's essentially about public fights that alarm or disrupt the public.
Exactly. Making a public space feel unsafe or uncomfortable because people are brawling.
So it's distinct from an unlawful assembly, which requires 5 or more people. This is about smaller, more direct confrontations. What are the key elements needed?
Yes, the numbers are different. It requires 2 or more persons, not 5. They must be engaged in fighting, which implies, a bilateral confrontation. Both sides are actively combative.
Not just one person attacking another.
Right. And it must occur in a public place. A fight in your private home wouldn't be a fray.
Yeah.
And most importantly, that fight must disturb the public peace.
That's essential.
Yes. A private quarrel, no matter how heated, if it happens without causing any public disturbance, isn't legally in a fray. Think of 2 individuals starting a proper fistfight on a busy street, causing passersby to stop, stare, maybe even step back in fear. That's in a fray. Or rival vendors in a public market coming to blows over a dispute, disrupting the market's functioning.
And the punishment for this, compared to rioting, it seems less severe.
It is. It's relatively minor, up to 1 month imprisonment, a fine up to $1,000, or both. This reflects that it's generally seen as a less serious breach of peace compared to rioting, but still clearly a violation of public order.
So what does this tell us about our expectations for behavior in public spaces?
This section really underscores the expectation that public spaces should be peaceful and safe for everyone. It's a reminder of the basic civility required in shared public areas, highlighting that even seemingly minor disturbances like a brawl can have legal consequences if they disrupt the public sense of security and peace.
When public order does break down, it's often public servants like police officers who step in to restore it. This puts them directly in harm's way, and Section 195 BNS seems to offer them specific, robust protection.
Absolutely. This provision offers enhanced protection specifically for public servants who are actively engaged in that critical and often dangerous duty of quelling public disturbances, things like riots, unlawful assemblies, or affrays.
It recognizes the risks they take.
It does. It recognizes the immense risks they take on our behalf in those volatile situations.
And the punishment for interfering with them while they're doing that specific job seems quite specific and severe, doesn't it?
It is. It's classified as an aggravated offense with serious graded punishments. If you actually assault or obstruct any public servant or use criminal force on them while they're trying to disperse an unlawful assembly, suppress a riot, or suppress an affray.
Okay, during those specific actions.
Yes, the punishment can extend to 3 years imprisonment, and this is significant, a mandatory minimum fine of not less than $25,000.
A mandatory minimum fine. Wow.
That mandatory minimum really highlights the seriousness with which the law views interference with these crucial duties. And even just threatening to assault, or attempting to obstruct, or threatening or attempting to use criminal force in that context carries a punishment of up to 1 year imprisonment, a fine, or both.
So the public servant must be performing these specific tasks, dispersing, suppressing, for this section to apply. It's not just any obstruction of any public servant.
Exactly. The context is key. The public servant must be performing these specific tasks for this section to apply. For example, individuals who physically attack or obstruct police officers attempting to disperse a riotous mob, or who threaten those officers to prevent them from acting, would clearly fall under this section.
What's the most important implication of this section for our society? Why is this protection so critical?
Well, this section is vital for ensuring that public servants can actually perform their critical, often hazardous duties of restoring public order without fear of attack or hindrance.
It lets them do their job.
Yes.
Yeah.
It directly links to our ability as a society to maintain peace and respond effectively to disorder. It really prompts us, I think, to consider the significant risks our public servants take on our behalf, and the absolute importance of allowing them to do their job without illegal interference.
Okay, so beyond physical violence and direct obstruction, the law also addresses actions and, importantly, words that sow discord and threaten the very fabric of society. This moves us into the really sensitive realm of hate speech and divisive narratives.
Yes, Section 196 is a critical tool, really, for trying to maintain social cohesion in a diverse society like India. It criminalizes hate speech and other actions that deliberately promote discord and enmity between different societal groups.
So the core concept is penalizing acts that foster division based on identity.
Exactly. It's about preventing the deliberate creation of hatred or ill will between groups.
And the scope of prohibited acts seems incredibly broad, especially with the mention of electronic communication. It covers more than just spoken words, doesn't it?
It is indeed very broad. The law covers promoting or attempting to promote disharmony or feelings of enmity, hatred, or ill will between different groups based on religion, race, place of birth, residence, language, caste, community, or any other ground whatsoever.
Any other ground, that's why.
It's extremely broad.
Yeah.
And crucially, it explicitly includes various means: words, spoken or written, signs, visible representations, and electronic communication. That last inclusion is particularly relevant today in our hyper-connected digital world.
So it's not just inflammatory speeches in public squares anymore, but what you might create or share online.
Precisely, that's covered. And beyond just speech, it also covers acts prejudicial to harmony.
What does that mean?
Committing any act that is prejudicial to the maintenance of harmony between such groups and which disturbs or is likely to disturb public tranquility. So this is about concrete actions, not just rhetoric, that harm intergroup relations and peace.
Okay.
And there's a significant addition targeting organizing militant activities, things like exercises, movements, or drills, if they are done with the intent or knowledge that participants will use or be trained to use criminal force or violence against any religious, racial, language, or regional group, caste, or community.
And causing fear is key there.
Yes, such activity causing fear or alarm or insecurity among members of that group is a key element.
What are the consequences for these serious offenses? Promoting hate seems very serious.
Generally, these offenses can lead to imprisonment for up to 3 years, a fine, or both. However, there's an aggravated punishment that really underscores the heightened sensitivity of certain locations.
Where specifically?
If any of these offenses are committed in any place of worship or in any assembly engaged in the performance of religious worship or religious ceremonies, the punishment is higher, up to 5 years imprisonment and a fine.
That makes sense. Exploiting sacred spaces for hate is particularly egregious.
The law clearly recognizes the profound potential for mischief and harm in such sensitive settings.
This sounds like a powerful provision. What's the biggest takeaway here for how we interact in a diverse society, especially online?
Well, this is a critical tool for combating hate speech and activities that threaten social harmony and public order. It attempts to strike that very delicate balance between freedom of expression and the imperative to prevent incitement to violence and maintain the secular fabric of society.
It's a balancing act.
It is. And it asks all of us, really, to consider the profound impact of our words and actions on intergroup relations, especially in our interconnected world, where things can spread so fast.
Building on that idea of social harmony, Section 197 seems to focus more specifically on divisive narratives that undermine national unity itself.
That's right. The core concept here is penalizing specific types of speech and publications, again, explicitly including electronic communication that directly jeopardize India's sovereignty and security, or create disaffection among different groups of citizens, or attack national integrity through false information.
So this is about protecting the very idea of India as a unified nation, not just relationships between communities within it. It seems to tackle rhetoric that attacks the foundations of the state.
Exactly. The prohibited acts are quite focused. First, it targets imputations against allegiance. This means making or publishing claims that any class of persons cannot be loyal to the Constitution or uphold India's sovereignty and integrity simply because of their group identity, whether religious, racial, linguistic, or any other.
Questioning the loyalty of entire groups.
Yes, it strikes at the heart of national loyalty and trust between citizens and the state, and among citizens themselves.
And protecting equal citizenship is also a key aspect here.
Yes, that's the second point. Denying citizen rights. Asserting or propagating that any class of persons should be denied or deprived of their rights as citizens of India based purely on their group identity. This clause is a direct protection of equal citizenship for all and a strong message against discriminatory rhetoric.
Okay.
It also addresses making or publishing assertions about the supposed obligations of a particular class of persons that cause or are likely to cause disharmony, enmity, or ill will between them and other groups, focusing on divisive rhetoric impacting group relations.
And finally, a crucial one for our modern information landscape. How does it deal with fake news or disinformation when it threatens national security?
Indeed, the fourth point directly addresses false or misleading information, jeopardizing sovereignty, unity, integrity, or security. This means making or publishing false or misleading information that directly threatens the fundamental security and unity of the nation. This is highly relevant in the age of sophisticated disinformation campaigns, both domestic and foreign.
What are the potential consequences for these actions that target national unity?
Generally, they carry imprisonment for up to 3 years, a fine, or both. And similar to Section 196, if this offense is committed in a place of worship or during religious ceremonies, the penalty is aggravated to up to 5 years imprisonment and a fine, reflecting the heightened vulnerability of such settings to divisive messaging.
So what does this significant provision ultimately mean for us as citizens? How should we think about it?
Well, this is a powerful provision for protecting national integration and countering propaganda that seeks to divide citizens or undermine the state itself. It underscores the importance of a common sense of citizenship and highlights the inherent dangers of misinformation, especially when it threatens the very unity of the nation.
It makes you think about what you share online.
It really challenges us to critically evaluate the information we consume and share, understanding that our words and the information we amplify can have national implications.
Okay, after seeing how the BNS aims to keep our public spaces safe and united, we now turn to, well, the very backbone of our legal system, the public servants themselves.
A crucial element.
Just as crucial as preventing external disorder is ensuring internal integrity, ensuring those entrusted with power are held to the highest standards. Because, what good are laws if those who enforce them don't abide by them?
Exactly. Public trust is paramount.
So, what happens when public servants themselves disregard the law? Section 198 BNS addresses general disobedience that causes harm. It feels like a fundamental check on unchecked power. Hashtag tag 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 2.1.1 general disobedience causing injury, Section 198 BNS.
This section really is fundamental to the rule of law for public functionaries. The core concept here is that a public servant is held criminally liable for knowingly disobeying legal mandates related to their official conduct.
Okay.
When such disobedience is coupled with an intent to cause injury or knowledge that injury is a likely consequence.
So it's not just a procedural mistake.
No, it's more than that. It's a deliberate act of disobedience with foreseeable harm to a citizen.
So it's not just about breaking a rule, but breaking a rule knowing it could hurt someone's body, mind, reputation, or even...
Exactly. That broad definition applies. The key elements are clear. The accused must be a public servant, and they must knowingly disobey a legal direction.
They have to know they're breaking the rule.
Yes, they must be aware of the law and consciously choose to disregard it. And the crucial mens rea, the guilty mind, here is the intention to cause that broad injury or knowing it's likely to cause injury.
Can you give an example?
Sure. An officer is legally directed, maybe by a court, to seize property to satisfy a decree in favor of an individual. Let's call him Mr. Z.
Okay.
If that officer knowingly disobeys this direction, fully understanding that this failure will likely cause financial harm that's injury to property to Mr. Z, then that officer has committed an offense under this section.
And the punishment for this deliberate dereliction of duty causing harm?
It's simple imprisonment for up to 1 year, a fine, or both. While it might seem minor compared to some other sections we've discussed.
The principle is huge.
Exactly. The true weight is the criminal liability placed on public servants for such deliberate harm caused by their disobedience.
What's the biggest takeaway from this for us as citizens? How does it protect us?
Well, this section ensures that those in positions of power cannot simply disregard legal procedures when it suits them, especially if their actions or inactions harm citizens. It reinforces that vital duty of care that public servants owe to the public.
And our right to expect lawful conduct.
Yes, our right to expect lawful, accountable conduct from them. It's about ensuring the foundational integrity of public administration. Hashtag 2.1.2, specific disobediences in investigation and victim care. Sections 199 and 200 BNS.
Okay, beyond that general disobedience, the BNS 2023 also zeroes in on very specific and critical failures by public servants, particularly in how they handle investigations and care for victims. These sound like truly impactful changes.
That's right. These are crucial provisions, really designed to address some historical pain points in the justice system, particularly for vulnerable people.
Let's start with Section 199 BNS, which focuses on procedural integrity and significantly mandatory FIRs for certain grave offenses. I hear this is particularly significant for victims of serious crimes.
This is a profoundly important provision. It specifically criminalizes serious derelictions of duty by public servants, especially those involved in investigations. The aim is to ensure strict adherence to procedural safeguards and, crucially, the mandatory recording of information for serious crimes.
So what are the key prohibitions or mandates here for public servants?
There are three key ones, all aimed at protecting citizens and ensuring the law is followed correctly. Firstly, it prohibits unlawful summons for investigation.
Meaning?
Public servants cannot knowingly disobey any legal direction that prohibits them from requiring someone's attendance at a particular place for investigation. Think of laws protecting women or children from being called to police stations unnecessarily, protecting vulnerable individuals during investigation.
Okay, that makes sense. What's the second?
Secondly, it targets prejudicial disobedience in investigation. This is where a public servant knowingly disobeys any other legal direction regulating how an investigation should be conducted if this causes prejudice to any person.
Like conducting an illegal search.
Exactly.
Yeah.
Conducting illegal searches without proper warrants or violating other procedural rules in a way that harms someone's rights during the investigation.
And the third one, the failure to record FIR for specified offenses, seems to be the most impactful, potentially. This directly addresses that critical first step in accessing justice, right?
It absolutely is. This part penalizes a public servant who fails to record any information given to them about a comprehensive list of serious, cognizable offenses.
And what kind of offenses are we talking about?
What's crucial here is the focus on vulnerable victims. The list primarily comprises grave crimes against women and children, offenses like rape, sexual assault, acid attacks, human trafficking, and others under specific BNS sections. Also other serious crimes.
So the intent is clearly to ensure these serious cases get registered promptly.
Unquestionably. It clearly highlights the legislative intent to ensure prompt registration of such cases and prevent victims from being turned away or their complaints minimized or ignored at the police station level.
This feels like a powerful step towards police accountability. What are the consequences for public servants who fail in these duties under Section 199?
The punishment is not just significant, it's mandatory and rigorous. It's rigorous imprisonment for a term not less than 6 months, but which may extend to 2 years. A&D, a fine.
Rigorous imprisonment and a mandatory minimum of 6 months.
Yes, that mandatory minimum rigorous imprisonment truly underscores the seriousness with which the law views these derelictions of duty. It makes it absolutely clear that such actions, like refusing to file an FIR for these specified crimes, will not be tolerated.
So what does a specific provision ultimately mean for you, the citizen, particularly if you or someone you know is a victim of a serious crime like those listed?
This is a crucial provision for police accountability and for ensuring justice, especially for vulnerable victims. It codifies the principle that lodging an FIR, the first information report, is mandatory for these grave cognizable offenses.
Meaning the police must register the crime.
Yes. Cognizable means they can investigate without a warrant and must register the FIR. And this section imposes severe penalties on public servants who obstruct this fundamental step in accessing justice. It empowers citizens to expect prompt and lawful action from investigating authorities. It's a significant move towards transparency and responsiveness.
Now, moving from investigations to medical care for victims, Section 200 BNS also addresses a critical duty, ensuring immediate medical attention is provided.
Yes, Section 200 BNS deals with mandatory treatment for victims. The core concept is that it penalizes any person in charge of a hospital, public or private, who contravenes the legal mandate laid out in Section 397 of the Bhartiya Nyaya Sanhita 2023, that's the BNSS, the procedural code which requires them to provide treatment to victims.
And this applies to all hospitals, private ones too.
Yes, the section explicitly covers all hospitals, whether run by government, local bodies, or private entities. No exceptions.
So a hospital, whether private or public, can't deny essential first aid or treatment just because a police report hasn't been filed yet, especially for victims of serious crimes like rape or acid attacks.
Precisely. While we're assuming the content of BNSS Section 397 mirrors the previous CRPC Section 357C, the principle is that all hospitals must provide free first aid or medical treatment to victims of specific serious crimes, like acid attacks or rape, without waiting for police reports or other formalities.
So the scenario where a victim is turned away.
That scenario is exactly what this law aims to prevent. Imagine a victim of rape or an acid attack is brought to a private hospital, and the doctor or person in charge refuses to provide immediate medical examination and treatment, insisting on a police report first, despite the law mandating immediate care. That refusal would fall directly under this section.
And the punishment for such a refusal?
Imprisonment up to 1 year, a fine, or both. While the punishment might seem less severe than, say, Section 199, the very existence of this law sends a powerful message about prioritizing the victim's immediate medical needs.
What's the most important implication of this provision for you and your family in a time of crisis?
This provision powerfully upholds a victim's fundamental right to immediate medical care, which is intrinsically linked to their right to life and health under the Constitution.
It puts life first.
Yes, it prevents denial of treatment and ensures that medical emergencies are addressed promptly, prioritizing human life and well-being above bureaucratic procedures. It's a direct and vital safeguard for you and your loved ones in times of crisis, ensuring compassion and immediate care are enshrined in law. Hashtag 2.2 Integrity in Records and Transactions, Sections 201, 202, 203 BNS.
The integrity of public administration isn't just about how public servants respond to crime or treat victims. It's also crucially about the truthfulness of records and fairness in financial dealings.
Absolutely. Accurate records and fair processes are the bedrock of trust.
The BNS 2023 seems to have robust provisions for this, recognizing that if you can't trust the records, you can't trust the system. Hashtag 2.2.1, falsifying official documents, Section 201 BNS.
Exactly. The core concept of Section 201 is to criminalize the deliberate falsification of official documents or electronic records by public servants who are entrusted with their preparation or translation.
Okay.
When it's done with the intent to cause injury or knowledge that injury is likely, this strikes right at the heart of potential official corruption and abuse of power through record manipulation.
So a public servant can't just knowingly make false entries in land records or court documents or any official record to cause harm, whether that harm is physical, reputational, or financial.
Precisely. The key elements are: the person must be a public servant whose duty involves preparing or translating a document or electronic record. They must know or believe the record they are framing or translating to be incorrect.
They know it's wrong.
Yes, and this act must be done intending to cause injury or knowing it to be likely to cause injury to any person. That broad definition of injury applies again.
Can you give an example?
Sure. Think of a village accountant who deliberately makes a false entry in land records, specifically to cause wrongful loss and injury to property to a particular landowner.
Right, altering ownership details.
Or perhaps a court clerk who intentionally prepares an incorrect copy of a judgment with the aim of misleading one of the parties involved in a legal dispute.
These actions directly undermine justice and public trust. What are the consequences under Section 201?
Imprisonment for up to 3 years, a fine, or both. This reflects the serious nature of undermining the foundational truthfulness of public records, which so many rights and processes depend on.
Why is this section so vital for you, the citizen, and for the overall functioning of society?
Well, official records form the backbone of governance and our legal rights. This section is vital for maintaining the integrity and accuracy of these records.
Trusting the paper trail.
Exactly. It prevents abuse of official position through falsification, and it protects individuals from potentially devastating harm caused by such malicious actions. It's fundamentally about ensuring the foundational truthfulness of our public systems and the data that governs our lives, from land ownership to judicial proceedings. Hashtag 2.2.2, avoiding conflicts of interest, Sections 202 and 203 BNS.
Public servants are, by definition, meant to serve the public interest, not their own private interests or pockets.
That's the ideal, yes.
The BNS 2023 specifically addresses potential conflicts of interest, recognizing that private gain can easily corrupt public duty.
That's a critical area for upholding public trust. The law targets specific situations where personal interest could directly clash with public responsibilities.
Let's start with Section 202 BNS, which deals with unlawful engagement in trade. What's that about?
The core concept here is pretty straightforward. It penalizes a public servant who unlawfully engages in trade when they are legally bound as such public servant not to engage in trade.
So if their service rules say no private business, they can't run one.
Correct. These prohibitions usually stem from government service rules or specific statutes designed to prevent conflicts of interest.
Why are those rules there?
To ensure public servants devote their full attention to their official duties, to maintain impartiality, and to prevent situations where their private business might benefit from their public position, or vice versa. It's about ensuring undivided loyalty to the public good.
An example.
A full-time government employee whose service rules explicitly forbid engaging in private business nevertheless sets up and actively manages a commercial enterprise on the side.
And the punishment for this, interestingly, includes community service as an option. That feels quite modern.
Yes. The punishment is simple imprisonment up to 1 year, a fine or both, or community service. The inclusion of community service is indeed a modern approach, offering a non-custodial option that can be rehabilitative and allows for a direct contribution back to society, which feels appropriate for certain service-related offenses.
So this is fundamentally about preserving the integrity and impartiality of public service.
Absolutely. It ensures that public servants' private commercial interests do not clash with their public responsibilities, fostering greater trust in government by minimizing avenues for undue influence or distraction from their primary duties.
Now, related to that, Section 203 BNS deals with unlawful purchase or bid for property. This sounds like it's aimed squarely at preventing insider dealing or abuse of position in property matters.
It does. The core concept here is that it penalizes a public servant who unlawfully purchases or bids for certain property when they are legally bound not to do so.
And it covers different ways of doing it sneakily.
Yes, it applies whether they do it in their own name, in someone else's name, what's often called benami, jointly with others, or in shares. The law tries to cover the loopholes.
And the why behind this prohibition.
It's clearly to prevent public servants from exploiting their official position or any insider knowledge they might have for personal gain in property transactions, especially those connected to their official capacity. It's about ensuring fairness and transparency in public dealings with property.
And what's the punishment like here? Is there a strong deterrent against this kind of malpractice?
Beyond the potential for simple imprisonment up to 2 years and a fine, there is a crucial additional consequence to act as a very strong deterrent.
What's that?
If the property is actually purchased unlawfully under this section, it shall be confiscated.
Mandatory confiscation.
Yes, this mandatory confiscation is a powerful deterrent and also serves as a means of restitution, ensuring that any illicit gains from abusing public office are not retained.
Can you give an example of where this might apply?
Sure. Imagine a public servant who is conducting an official auction of government property. If they are legally barred from bidding for it themselves due to their role,
Right.
but they arrange for a proxy or a relative to bid on their behalf,
Okay.
that would fall under this.
Okay.
Or an officer involved in land acquisition proceedings for the government is prohibited by rules from buying land in that specific area during the process, but proceeds to do so anyway, perhaps anticipating a rise in value.
So this section acts as a really important check against potential corruption and abuse of office in property dealings, ensuring fairness and transparency.
It does. It tells us very clearly that those who serve the public cannot illicitly benefit from their position, especially when it involves public resources or processes like auctions and land acquisition. It reinforces that public office is a public trust. Hashtags 2.3, protecting the identity of public servants, sections 204 and 205 BNS.
Lastly, in this part on public servants, let's look at how the BNS 2023 protects the very identity and symbols associated with public servants. This is about ensuring that their authority isn't falsely assumed or misused by imposters.
Yes, this is vital for maintaining public order and preventing various kinds of fraud and deception. Hashtag 2.3.1, personating a public servant, section 204 BNS. Section 204 BNS specifically criminalizes the act of falsely pretending to be a public servant or falsely impersonating another specific person who holds such office.
Okay, pretending to be someone you're not.
And then this is the key part, acting or attempting to act under color of such office.
Yeah. So it's not just dressing up. It's actively trying to use the authority that comes with that fake identity.
Exactly. It's about a full-on fraudulent assumption of power and is a direct threat to public safety and trust. The key elements are: you must know you don't hold the office or are falsely impersonating someone who does. And crucially, it's about doing or attempting to do something that implies the authority of that office acting under color of office.
Like what, for instance?
For instance, a person dresses up as a traffic police officer, maybe sets up a fake checkpoint, and then starts stopping motorists and demanding fines.
Right, classic scam.
Or an individual falsely claims to be a food safety inspector and tries to inspect a restaurant with the aim of extorting money from the owner.
What's the punishment for such a serious offense that directly undermines public authority and potentially harms citizens?
The punishment reflects the seriousness. It's imprisonment for not less than 6 months, but which may extend to 3 years and a fine.
Another mandatory minimum sentence.
Yes. The mandatory minimum, again, reflects the gravity of undermining public authority and the potential harm that can be caused to citizens through such deception.
What's the biggest takeaway from this for the public? Why is this protection important for you?
Well, this law directly protects you, the public, from being deceived or harmed by individuals falsely claiming official authority. It also safeguards the dignity and the authority of genuine public office.
Prevents misuse.
Yes, preventing its unauthorized assumption and misuse. It's fundamentally about preserving trust in the uniform, the badge, and the legitimate role that public servants hold, ensuring you know who you can truly rely on and whose authority is genuine. Hashtag tag 2.3.2, wearing garb or carrying token with fraudulent intent, Section 205 BNS.
Okay, but what about simply wearing a uniform or carrying a badge that looks official, maybe very similar to a real one, but without necessarily performing an official act? Does the BNS 2023 cover that more subtle form of deception? Maybe just trying to get respect or access you're not entitled to?
Yes, Section 205 BNS addresses this specific scenario. The core concept here is that it penalizes wearing any uniform garb or carrying any badge, token, that resembles those used by a particular class of public servants,
Okay.
with the intention or knowledge that doing so will likely make others believe you actually belong to that class of public servants.
So this is distinct from Section 204 because it doesn't require an act under the assumed authority. It's more about the deceptive use of the symbols themselves.
Precisely. That's the key difference. While Section 204 requires acting or attempting to act under the assumed authority, Section 205 focuses purely on the deceptive use of the symbols, the uniform or the token, even if no specific official act is performed or attempted.
What are the key elements here?
The key elements are, you're not actually a member of that class of public servant, the garb or token you're using resembles an official one, and you have fraudulent intent or knowledge. You intend people to be misled, or you know it's likely they will be.
Could you give an example?
Sure. Imagine a civilian wears a security guard uniform that very closely resembles a police uniform, maybe intending to mislead people into thinking they have police authority just to gain some advantage, like getting through a gate faster.
Oh.
Or someone flashes a fake badge that looks very much like an official government token, perhaps to try and get past a checkpoint or gain entry somewhere they shouldn't.
And the punishment for this, is it as severe as Section 204?
No, it's less severe, reflecting the lesser degree of immediate harm or action. The punishment here is imprisonment up to 3 months, or a fine up to $5,000, or both. Still a penalty, but significantly less than for actually acting under false pretenses.
So what does this tell us about the significance of official symbols like uniforms and badges?
Well, this section essentially prevents the misuse of official uniforms and insignia. It protects their distinctiveness and the authority they represent. It's a reminder that symbols of public service carry weight and trust, and they are not to be taken lightly or used deceptively, even if you don't try to exercise fake power.
Our final part of this deep dive takes us into the area known as contempt of lawful authority. This is really all about how individuals interact with the state's official processes and public servants, and what happens when those interactions involve things like evasion, obstruction, or maybe lack of truthfulness. It seems to define the civic responsibilities of citizens in supporting, or at least not hindering, the justice system and public administration. Hashtag 3.1, evading and obstructing official communications. Sections 206, 207, 208, 209 BNS. Let's start with something that probably happens quite often. People trying to dodge official communications from public servants. Avoiding getting served with court papers or notices. It seems like a common issue, but the BNS makes it clear it has serious legal consequences.
Yes, the law takes this seriously. The core concept of Section 206 criminalizes the deliberate act of making yourself unavailable, specifically to evade the lawful service of official communications, like summonses, notices, or orders issued by competent public servants.
So it's about frustrating the system.
Exactly. It's about frustrating the very mechanism of justice and administration by preventing official communication from reaching you.
So it's not just, say, not being home when someone comes by with papers. It implies something more deliberate.
Exactly. The term absconds implies more than just not being found by chance. It suggests a conscious effort to conceal oneself or perhaps depart from one's usual residence specifically in order to avoid being served. You know you're wanted and you actively hide.
Can you give an example?
Sure. A person knows a court summons has been issued for their appearance as a witness,
To avoid receiving it, they deliberately leave town without informing anyone of their whereabouts, specifically intending to dodge the service.
Are there different levels of punishment for this, maybe depending on what kind of document is being evaded?
Yes, the punishment is graded. For evading general official communications, under Clause A, it can lead to simple imprisonment up to 1 month, or a fine up to $5,000, or both. However, if the summons, notice, or order is specifically to attend in person or by agent, or to produce a document or electronic record in a court, under Clause B,
Ah, related to court proceedings.
yes, then the stakes are higher. The punishment extends to simple imprisonment up to 6 months, or a fine up to $10,000 to 1,000, or both. The higher penalty for court matters clearly underscores their critical importance to the administration of justice.
What does this section tell us about our civic duty and the administration of justice? Why is it an offense?
This section ensures the effectiveness of legal and administrative processes. It tells us that deliberately hiding to avoid official communications isn't just an inconvenience for the authorities. It's a punishable offense that actively frustrates the administration of justice and vital public functions. It reinforces the principle that you cannot simply opt out of your legal obligations by making yourself unavailable. Hashtag tag tagged 3.1.2, actively preventing service or publication. Section 207 BNS.
Okay, building on that idea of evading service, Section 207 BNS seems to target more active forms of obstruction, not just hiding, but physically stopping the process.
That's right. The core concept here is criminalizing active obstruction or interference with the lawful service, or even the public display of official processes. It's about direct sabotage of how legal information reaches people.
So if someone tries to serve me papers and I literally snatch them and tear them up, that would fall under this section.
Precisely. That's a classic example. It covers various obstructive acts, such as intentionally preventing service, whether on oneself or trying to stop service on another person, intentionally preventing the lawful affixing or pasting of a notice.
Like tearing down a notice from a board.
Yes, or removing an already affixed notice, or even preventing the lawful making of a public proclamation by an official.
Okay.
Another example. A notice of a public auction by a government department is lawfully pasted on a public notice board, and someone intentionally removes it, maybe to prevent potential bidders from knowing about it. That's obstruction under this section.
And the punishment for this act of prevention, is it similar in severity to just absconding under Section 206?
Yes, it's similarly graded. For general cases, Clause A, simple imprisonment up to 1 month, or a fine up to $5,000, or both. If the process relates specifically to court attendance or the production of evidence in court, Clause B, the punishment extends to simple imprisonment up to 6 months or a fine up to $10,000, or both. Again, reflecting the greater importance attached to court-related processes.
What's the biggest takeaway from this section for the integrity of our legal system? Why protect these notices?
Well, this provision protects the fundamental integrity of our legal and administrative notification systems. It penalizes the deliberate sabotage of how official communications reach people.
Ensuring the message gets through.
Exactly. Ensuring that justice and public functions are not hindered by someone actively blocking the flow of information. It highlights the importance of respecting official processes and allowing them to operate unimpeded.
Sometimes people aren't just evading service. They receive the notice, but then outright ignore orders to appear before an authority. The BNS 2023 has specific provisions for this too, recognizing that the whole system relies on people actually showing up when lawfully required.
Yes, that's critical. Starting with Section 208 BNS, which addresses general non-attendance in obedience to an order. The core concept here is penalizing the intentional failure to attend at a specified place and time when you are legally bound to do so by an order from a competent public servant.
So if a court summons me as a witness, or maybe some other government body requires my presence legally, I can't just decide not to show up because I don't feel like it.
Not if you're legally bound to attend. This section covers intentionally omitting to attend or even showing up and then intentionally departing from the place before it is lawful to leave, maybe without permission.
Sneaking out early.
Something like that. The punishment is graded, similar to the previous sections. Generally, Clause A, simple imprisonment up to 1 month or a fine up to $5,000, or both. But again, if the requirement is to attend in a court, Clause B, the punishment extends to simple imprisonment up to 6 months or a fine up to $10,000, or both, emphasizing the judiciary's authority.
An example here.
A person is legally bound, maybe by a subpoena or summons, to appear before a high court or a district judge as a witness on a specific date, and they intentionally fail to appear without lawful excuse.
What does this section mean for the smooth running of our legal and administrative systems?
This section upholds the authority of public servants and courts. It ensures individuals comply with their legal obligations to appear when summoned for official or judicial purposes. It's absolutely essential for the smooth and efficient administration of justice and public functions, as proceedings simply cannot advance if key people just fail to show up.
And then there's Section 209 BNS, not appearance in response to a proclamation. This sounds even more serious. It's often related to absconding criminals, right? People who are formally declared as wanted.
Yes, this creates a distinct and significantly more severe offense. It's specifically for failing to appear in response to a formal proclamation issued under Section 84 of the BNSS 2023, the Procedural Code. These proclamations are typically issued for accused persons who are absconding, trying to evade arrest or trial, and they're a formal public last resort to compel someone to present themselves to justice.
So the punishments are expectedly much higher here, reflecting the gravity of ignoring such a direct and public call from the judicial system.
Significantly higher.
Hmm.
For general failure to appear in response to such a proclamation, the punishment is imprisonment up to 3 years, or a fine, or both, or community service is also an option here.
Okay.
But, and this is a critical distinction, if a formal declaration has been made under Section 84.4 of the BNSS, pronouncing the person a proclaimed offender.
Which is a formal legal status.
Exactly. Then the punishment is dramatically more severe. Imprisonment up to 7 years and a fine. Not or, but and. This is a key distinction designed to strongly deter absconders and enforce accountability for those who actively and persistently evade justice.
Can you paint an illustrative scenario for this elevated offense? When would someone face that 7-year possibility?
Okay. A court issues a public proclamation against an individual accused of a serious crime who is known to be absconding. The proclamation requires them to appear before the court by a certain date. If that person fails to appear by the deadline, they are immediately liable under the first part of Section 209. If subsequently the court follows the procedure under BNSS Section 84 and formally declares them a proclaimed offender due to their continued non-appearance and evasion, then they face that much higher potential penalty of up to 7 years plus a fine upon eventual apprehension.
That powerfully deters individuals from frustrating the administration of justice by absconding.
It does. What's the overall impact of these non-attendance provisions on the legal system?
Well, these sections, particularly Section 209, are a powerful tool to deter by absconding and ignoring formal judicial proclamations. They highlight the severe consequences of actively evading the legal process, especially for those deemed proclaimed offenders, and underscore the state's unwavering commitment to ensuring justice is ultimately served, even if delayed. Truthfulness, as we've touched upon, is the absolute bedrock of any functioning justice system. If information can't be relied upon, the entire edifice crumbles.
Absolutely. Without truth, there's no justice.
The BNS 2023 seems to have a whole series of sections designed specifically to ensure that not only is information provided when required, but critically, that it is truthful information.
Yes, starting with Section 210 BNS, which penalizes the intentional omission to produce a document or electronic record when you are legally bound to do so before a public servant or a court.
So not just hiding yourself, but hiding evidence.
Exactly. The core concept here is about ensuring compliance with legal obligations to present evidence, recognizing that vital information, whether physical or digital, must be made available for inquiries and judicial proceedings to arrive at the truth.
So I can't just decide not to give up a crucial document or, say, electronic records from my computer if I'm legally required to.
Absolutely not, if you are legally bound to do so. The key elements are that legal duty must exist, arising from a valid legal provision, order, or summons, and you must intentionally omit to produce it, meaning the failure must be deliberate, not accidental, or due to genuine inability. And yes, it explicitly includes electronic records now, reflecting modern evidence types.
An example of this.
A person is legally bound, perhaps by a court order, to produce a crucial contract document before a district court in a civil suit, and they intentionally fail to do so, maybe to disadvantage the other party. This could also apply to failing to produce financial records before a tax authority or case-related data to an investigating officer if lawfully summoned.
What are the consequences for withholding evidence like this, and what does this mean for transparency in legal processes?
The punishment is graded, similar to the non-attendance sections. If the document is to be produced to a general public servant, Clause A, it's simple imprisonment up to 1 month, or a fine up to $5,000, or both. If it's to be produced to a court, Clause B, it's higher.
simple imprisonment up to 6 months, or a fine up to 10,000, or both.
Again, higher for courts.
Yes. This section ensures compliance with legal obligations to produce evidence, actively preventing the obstruction of justice or administrative functions that can result from the deliberate withholding of necessary information. It's fundamentally about ensuring transparency and cooperation with official inquiries, making sure vital pieces of the puzzle aren't deliberately hidden from view.
Okay, beyond producing specific documents when asked, there's also the fundamental duty in some cases to actually give information to public servants, and critically, to ensure that information is truthful. These next sections feel like they're about ensuring the flow of accurate data needed to maintain public order and safety.
Correct. Let's look at Section 211 BNS first, which deals with omission to give notice or information. The core concept here is penalizing the intentional omission to give legally required notice or information to a public servant.
So this isn't just volunteering information, it's when the law requires you to report something.
Precisely. This isn't a general duty to tell authorities everything you know. It applies only when you are legally bound to give that specific notice or information. This duty must be imposed by law, perhaps by specific statutes or rules relevant to a situation.
Like if I witness certain serious crimes, or maybe I have a legal duty as a village headman or something.
Exactly. For instance, a village headman might be legally mandated by state law to report the commission of certain offenses occurring in their jurisdiction. If they intentionally fail to do so, they could be liable under this section. Or perhaps someone legally required under public health laws to report a dangerous infectious disease outbreak intentionally withholds that information from public health officials.
And the punishment varies depending on what information is withheld.
Yes, it's graded. For general cases, Clause A, simple imprisonment up to 1 month, or a fine up to 5,000, or both. However, if the information relates specifically to the commission or prevention of an offense or the apprehension of an offender, Clause B.
Information crucial for law enforcement.
Right. Then the punishment extends to simple imprisonment up to 6 months, or a fine up to 10,000, or both. This higher penalty emphasizes the critical role citizens' timely information plays in effective law enforcement. There's also a specific clause, C, for orders under BNSS Section 394.
And it applies even to crimes outside India.
For Clause B, related to offenses, the explanation clarifies that offense includes certain grave acts committed outside India that would be punishable if done in India. This extends the duty to inform even for such serious extraterritorial crimes if you're legally bound to report it.
What does this section underscore about our collective responsibilities as citizens in maintaining order?
This section underscores our civic and, in specific cases, legal responsibility to furnish information that is deemed necessary for public administration and effective law enforcement. It ensures that public authorities receive crucial data they need to function effectively, especially in preventing crimes and apprehending offenders. It makes us potential partners in maintaining safety and order when the law requires it.
Okay, so that's about failing to give information. What about deliberately providing false information when you are legally bound to tell the truth? That seems even more insidious, actively misleading the authorities. Section 212 BNS covers that.
Absolutely. Lying to officials when you have a duty to be truthful is taken very seriously. The core concept here is penalizing the act of knowingly furnishing false information to a public servant when you are legally bound to provide true information on that subject. This is about active, deliberate deception that can derail investigations, lead to injustice, or obstruct vital public functions.
What are the key elements needed to prove such an offense? It seems you need to know it's false.
Yes. The key elements are, first, you must be legally bound to furnish information on that subject. Second, you furnish information is true. And third, you must know or have reason to believe that information to be false. It covers intentional lies.
And the punishment. Is it also graded based on this subject matter?
Yes, it is. For the general case, Clause A, providing false information when legally bound, it's simple imprisonment up to 6 months, or a fine up to 5,000 won, or both. But similar to Section 211, if the false information concerns the commission or prevention of an offense or the apprehension of an offender, Clause B.
Misleading a criminal investigation.
Exactly. Then the punishment extends significantly to imprisonment of either description, simple or rigorous, up to 2 years, or a fine, or both. Again, the broad extraterritorial definition of offense applies here too, emphasizing the seriousness of misleading officials, even about major international crimes, if there's a legal duty to provide info.
We have some classic illustrative scenarios for this in the old code, don't we? Stories that really highlight the danger of such lies.
Yes, quite vivid ones that illustrate the point well.
Imagine a landholder, knowing full well that a murder has occurred on their estate, deliberately misinforms the investigating magistrate that the death was accidental, perhaps due to a snake bite, to protect someone.
A clear obstruction of justice through falsehood.
Absolutely. Or, another classic example. A village watchman knows that a group of strangers passed through their village, and he knows they were intending to commit a dacoity, a serious gang robbery, in a nearby area. But when questioned by the police, he intentionally misinforms them, maybe sending them in the completely wrong direction to allow the criminals to escape.
What does this section tell us about the importance placed on the veracity of information in governance and law enforcement?
This section is crucial for ensuring the veracity, the truthfulness of information provided to public servants when there's a legal duty to provide it. It deters the deliberate misleading of authorities, which can severely hamper investigations, lead to grave injustice for victims or the wrongly accused, or obstruct vital public functions. It highlights the serious consequences of lying to officials when you have a legal duty to tell the truth, establishing truthfulness as a fundamental civic expectation in those contexts.
And finally, within this theme of truthfulness, we arrive at what many consider the cornerstone of truth-telling in any formal proceeding, the taking of oaths and affirmations. These aren't just ceremonial words. They carry profound legal weight under the BNS.
Indeed. They represent a solemn promise to tell the truth, and the law enforces that promise. Section 213 BNS penalizes refusing oath or affirmation.
So you can actually be punished just for refusing to swear or affirm.
Yes. The core concept is that refusing to take a legally required oath or make an affirmation to state the truth, when lawfully required to do so by a competent public servant, like a judge or authorized inquiry officer, fundamentally undermines the entire process designed to elicit truth.
So it's not optional if the law requires it in a formal setting, like a court or inquiry.
That's right. Oaths and affirmations are solemn declarations designed specifically to ensure truthfulness in legal and official proceedings. Refusing this fundamental obligation carries a penalty of simple imprisonment up to 6 months, or fine up to $5,000 or both. Imagine a witness summoned before a court or a legally authorized inquiry officer, like an ombudsman perhaps, simply refusing to take the oath or make the affirmation before testifying.
What does this mean for the authority and sanctity of legal proceedings?
This section upholds the sanctity and enforceability of proceedings where truth-telling under oath is absolutely essential. It tells us that these solemn obligations are not optional. They are a necessary component for the administration of justice to function fairly and effectively.
Yeah.
You can't participate without committing to truthfulness.
Okay, so that's refusing the oath. Next, Section 214 BNS deals with refusing to answer public servant authorized to question. This also sounds like it compels truthfulness once you've taken the oath. But what about the right against self-incrimination we hear about?
This is a really important one with a critical balance. Section 214 penalizes a person who, being legally bound to state the truth on any subject to a public servant, perhaps after taking that oath or due to a specific law, then refuses to answer questions asked by that public servant in the exercise of their legal powers to ask those questions. The key precondition is being legally bound to state the truth.
That seems like a strong power for the state to compel answers. But for our listeners, what about those constitutional protections, like the right to remain silent if answering could incriminate you? How does that fit in?
That's a crucial limitation and a vital balance in our legal system. This section must always be read subject to constitutional protections like Article 23 of the Constitution of India, which provides protection against self-incrimination.
So you can refuse to answer if it might land you in trouble.
Yes. A refusal to answer on the grounds that the answer might incriminate you, if that claim is validly made, would not be punishable under this section. It's a sophisticated legal balance between the authority's need for information to find the truth and an individual's fundamental constitutional rights.
A cornerstone of due process.
Absolutely. Outside of that protection against self-incrimination, if you refuse to answer a relevant question you're legally bound to answer, the punishment is simple imprisonment up to 6 months, or a fine up to €5,000, or both. An example would be a witness, after being sworn in court, refusing to answer a relevant question put by the judge or prosecutor without claiming self-incrimination.
So this section facilitates information gathering by authorities, but it also implicitly highlights a critical safeguard for individual liberties.
Exactly. It facilitates the gathering of information by public servants during investigations or inquiries, compelling truthful answers from those legally obligated. However, it equally reminds us of that fundamental right to remain silent when those answers could potentially incriminate you, highlighting a sophisticated legal balance.
Okay, then there's Section 215 BNS, which addresses refusing to sign statement. This seems less about truth-telling itself and more about authenticating what was said.
That's a good way to put it. The core concept here is penalizing the refusal to sign one's own statement when lawfully required to do so by a competent public servant.
The key being lawfully required.
Yes, that's crucial. If there is no specific legal obligation under the relevant procedural law to sign a particular type of statement, for instance, some statements recorded by police might not require the maker's signature, then refusal would not be an offense under this section. This section applies only where signing is a legal requirement for authentication or completion of the record.
And the punishment.
It's relatively minor. Simple imprisonment up to 3 months, or a fine up to 3,000 pra, or both. An example might be if a witness gives a formal statement to a magistrate under a procedure where the law requires such a statement to be signed by the maker to be valid, and the witness refuses to sign it after giving it.
So this ensures the proper authentication of statements recorded by public servants, reinforcing the procedural integrity of official documents.
Yes, precisely. It ensures that recorded statements, which are often necessary for evidentiary or record-keeping purposes, can be properly authenticated when the law demands it, adding a layer of reliability and finality to official processes.
And finally, the big one in this cluster, Section 216 BNS, false statement on oath or affirmation. This isn't about refusing, but about actively lying after promising to tell the truth.
This is about active falsehoods in a solemn context. The core concept is penalizing the act of knowingly making a false statement when you are under a solemn legal obligation, an oath or affirmation, to tell the truth before a public servant or other person legally authorized to administer that oath or affirmation.
What are the key elements here?
Key elements include: first, being legally bound by an oath or affirmation to state the truth. Second, making a statement that is actually false. And third, the mental element, knowing or believing it to be false or not believing it to be true. This covers not just intentional lies, but also making statements recklessly, without knowing or caring if they are true.
How does this differ from the offense of perjury, which we usually associate with lying in court? Is this broader?
It is similar in principle to giving false evidence, which is covered by other sections like S227 BNS, specifically for judicial proceedings. But this section, Section 216, potentially covers a broader range of situations. It applies to false statements made under oath or affirmation to public servants or other authorized persons, which might include things like affidavits sworn before an authorized official, or perhaps giving false testimony under oath during a departmental inquiry conducted by a public servant empowered to administer oaths, even if that inquiry isn't strictly a judicial proceeding.
So it extends the sanctity of the oath beyond the courtroom.
In essence, yes. The punishment reflects this seriousness. Imprisonment up to 3 years, aided a fine.
So what does this section mean for the truth as a cornerstone of our public and legal interactions?
This provision powerfully upholds the sanctity of oaths and affirmations, aiming to ensure the veracity of information provided in a wide range of official and quasi-judicial proceedings. It's about maintaining truth as a cornerstone of public interactions and the administration of justice, sending a clear message that deliberate falsehoods made under a solemn promise to be truthful have very serious consequences. Hashtag tag 3.3, active obstruction and coercion, sections 217, 218, 219, 220, 221, 222, 223, 224, 225, 226 BNS.
We've covered a lot on information and truthfulness. Now, let's delve into the final set of offenses under contempt of authority. These involve more active forms of obstruction and even coercion against public servants and the justice system itself. These seem to be about direct challenges to the lawful functioning of authority.
Yes, this first one, Section 217, is critical. It's designed to prevent the malicious weaponization of the legal or administrative system against others. It penalizes giving false information to a public servant.
We saw false information earlier in Section 212.
Right, but here there's a specific malicious intent attached. Section 217 applies when you give that false information with the intent or knowledge that it will cause the public servant to misuse their lawful power.
To misuse their power.
Thereby causing injury or annoyance to another person. It's about using the public servant as an unwitting tool to harm someone else.
So it's about trying to trick a public servant, feed them lies specifically to get them to do something that hurts or bothers someone else.
Precisely. The information given must be known or believed by the giver to be false, and the intent or knowledge is crucial. The purpose must be to cause the public servant to act, or maybe omit to act improperly based on that lie, or to use their lawful power in a way that causes injury, remember the broad definition, or annoyance to your target.
Can you give some examples of this kind of manipulation?
Sure. Falsely informing a magistrate that a subordinate police officer has been negligent in their duty, with a specific intent or likelihood that your false report will cause the officer to be dismissed or disciplined.
Okay, using a false complaint to get someone fired.
Or falsely informing a public servant, maybe customs or police, that someone is carrying contraband items. Knowing this false tip will likely lead to that person being searched, detained, and cause significant annoyance and trouble.
Right.
Or even falsely reporting to the police that you were robbed in a particular village, knowing that this will lead to police inquiries and cause annoyance and inconvenience to the innocent villagers.
And the punishment for this malicious manipulation of public power.
Imprisonment up to 1 year, or a fine up to $10,000, or both.
What's the biggest takeaway from this section for public trust and fairness? Why is it important to penalize this?
This section protects individuals from being victimized by the misuse of public power that's been instigated by someone else's false and malicious information. Crucially, it also safeguards public servants themselves from being unwittingly made instruments of private malice or mischief.
Protects the system from being abused.
Exactly. It's a powerful deterrent against weaponizing the legal or administrative system for personal vendettas, ensuring public officials are not easily turned into unwitting tools for bad actors trying to harm others. Hashtag 3.3.2. Resisting official actions. Sections 218, 219, 220, 221, 222, 223, BNS.
Okay, moving on from manipulation to directly resisting official actions. The BNS 2023 lays down clear rules for ensuring public servants can perform their duties without facing physical opposition or hindrance. It seems there are several sections covering different types of resistance.
Indeed. These sections collectively ensure the smooth operation of public administration and services by penalizing various forms of obstruction. Let's take Section 218 BNS first. It covers resistance to taking of property by lawful authority.
Like resisting eviction or seizure.
Exactly. It penalizes offering active resistance to a public servant who is lawfully taking property under their official authority. The key phrase here is lawful authority.
Meaning if the seizure itself is illegal, resisting might be okay.
Potentially, yes. Resistance to an unlawful seizure might be justified under other legal principles, perhaps like private defense of property. But this section applies when the public servant is acting lawfully. An example would be a court bailiff acting under a lawful warrant, attempting to seize property to satisfy a debt, and the owner or someone else physically resists or obstructs the bailiff, knowing they have lawful authority. The punishment is typically imprisonment up to 6 months, or a fine up to $10,000, or both.
And Section 219, obstructing sales.
Yes, Section 219 BNS criminalizes the intentional obstruction of a lawful sale of property being conducted by a public servant. Think of a court-ordered auction of property being conducted by an authorized official. If a person intentionally creates a disturbance or physically prevents potential bidders from participating, specifically to obstruct the sale, that's an offense under this section. Punishment is up to 1 month or a fine.
Then there's Section 220 about illegal bids at official sales.
Right, Section 220 targets specific malpractices at public sales conducted by officials. It penalizes two main things. First, bidding for or purchasing property on behalf of someone you know is legally barred or incapacitated from purchasing at that specific sale.
No.
Second, bidding without having any intention of actually honoring the obligations of the bid, essentially. Frivolous or fraudulent bidding to disrupt the process. The punishment here is quite low, up to 1 month, or a fine of only up to $200, suggesting it's viewed as a relatively minor infraction aimed at maintaining orderly sales.
So these sections are about upholding the efficacy of legal processes related to property and sales and preventing interference.
Exactly. And then more broadly, we have Section 221 BNS. This provides a general penalty for voluntarily obstructing any public servant in the discharge of any of their public functions.
A catch-all for obstruction.
Pretty much. It's a broad provision for obstructions that might not be covered by more specific or aggravated sections we've already discussed, like Section 195 for obstructing riot control. The obstruction must be voluntary, intentional, or done with knowledge of likelihood.
Examples of this general obstruction.
Maybe a person physically blocks a health inspector from entering premises for a lawful inspection they are empowered to conduct. Or someone refuses to cooperate with the census enumerator, collecting mandatory information in a way that amounts to active obstruction of their duty. The punishment is imprisonment up to 3 months or a fine up to $2,500, or both.
So this acts as a general deterrent against hindering public servants as they carry out their wide-ranging duties.
Yes, it ensures the smooth operation of public administration and services across the board. It reinforces the general expectation that citizens should not impede the lawful work of public officials.
And what if citizens are legally required to help public servants but fail to do so? Is that also an offense?
That's covered by Section 222 BNS, omission to assist public servant when legally bound. This penalizes the intentional omission to render legally required assistance to public servant in the execution of their public duty. Crucially, this duty to assist isn't a general one. It must arise from specific legal provisions that obligate you to help in certain circumstances.
Okay. And the punishment depends on the situation.
Yes, it's graded, with higher penalties for failing to assist in law enforcement situations. For the general case, Clause A, it's simple imprisonment up to 1 month, or a fine up to $2,500, or both. But Clause B, if assistance is demanded by a public servant who is legally empowered to demand it for specific critical tasks like executing court process, preventing an offense, suppressing a riot or a fray, or apprehending an offender or someone who has escaped custody.
More serious situations.
Right. Then the punishment extends to simple imprisonment up to 6 months, or a fine up to 5,000 tor, or both.
An example.
A police officer is attempting to apprehend a fleeing suspect who has just committed a robbery. The officer lawfully calls upon a nearby bystander to help stop the suspect. If the law in that jurisdiction actually obligates the bystander to assist in such a situation upon demand, and they intentionally refuse without a lawful excuse, they could potentially be liable under this section.
What does this tell us about collective responsibility?
This ensures that public servants can, when legally empowered, avail themselves of mandated assistance from citizens or other specified persons when necessary for effective law enforcement and the administration of justice. It speaks to our collective responsibility in certain legally defined critical moments to support officials in upholding the law.
Finally, in this subsection on resistance, we have Section 223 BNS, disobedience to order duly promulgated by public servant. This sounds like a powerful tool for enforcing general public orders.
It is. This section penalizes disobedience to a lawfully promulgated order of a public servant, especially if such disobedience causes or tends to cause certain specified harms.
What are the key elements here?
First, the order must be issued by a public servant lawfully empowered to issue it, and it must be properly promulgated, meaning made known to the public or the persons affected. Second, the accused must knowingly disobey the order.
They have to know about the order and choose to ignore it.
Yes. And third, the punishment is significantly consequence-based. The severity depends on the actual or likely harm caused by the disobedience.
How is it graded?
Clause A covers disobedience causing or tending to cause obstruction, annoyance, or injury, or the risk of it, to any person lawfully employed. That carries up to 6 months imprisonment or a $2,500 fine. Clause B covers more serious consequences. Disobedience causing or tending to cause danger to human life, health, or safety, or causing or tending to cause a riot or a fray. This carries up to 1 year imprisonment or a $5,000 fine.
And there's an important clarification on intent here, similar to the rioting section, right? It's not necessarily about intending the harm, but knowing that disobedience itself is likely to cause it.
Precisely. The explanation attached to this section is crucial. It clarifies that the offender need not intend to produce the specific harm, like a riot, or even contemplate it as likely. Knowledge of the order and the fact that their disobedience produces or is likely to produce harm is sufficient. This lowers the bar for proving intent, focusing instead on the foreseeable consequences of ignoring a lawful order aimed at preventing such harm.
Can you give the classic illustration for this?
Sure. An order is lawfully promulgated by a public servant, perhaps a district magistrate, directing that a potentially sensitive religious procession shall not pass down a certain street to avoid communal tension. A person, knowing this order exists, deliberately leads the procession down that prohibited street. If this act causes the danger of a riot breaking out, that person is liable under clouding, even if they claim they didn't want a riot, only wanted to exercise their right to procession. Their knowing disobedience, which foreseeably risked the riot, is enough.
What's the biggest takeaway here for civic responsibility and public order?
This section is essential for enforcing the lawful orders issued by public servants to maintain public order, safety, and convenience. Think of things like curfews, traffic diversions, restrictions on assemblies in sensitive areas, public health directives. It highlights that ignorance of the potential consequences of disobeying such public orders is generally not an excuse when the harm is foreseeable. It strongly reinforces the need for civic responsibility and adherence to lawful directives aimed at the collective good. Hashtag 3.3.3 Threats and Coercion Against Justice. Sections 224, 225, 226 BNS.
Finally, let's explore how the BNS 2023 deals with direct threats and coercion aimed at undermining the administration of justice itself. This is about ensuring that public servants can act without fear and that citizens can seek justice without facing intimidation.
Yes, this is a crucial final set of protections for the integrity of the system. First, we have Section 224 BNS, threat of injury to public servant.
What's at the core concept here?
The core concept is penalizing the act of threatening a public servant or someone they are interested in, like a family member, with the specific purpose of improperly influencing their official actions.
So, you absolutely cannot threaten a public servant's family to try and get them to do or maybe not do something related to their official duties. That seems fundamental.
No, that's precisely what this section targets. The threat must be a threat of injury. And remember, injury is broadly defined to include harm to body, mind, reputation, or property. The threat can be aimed at the public servant directly, or at someone the public servant is believed to be interested in.
Okay.
And the specific purpose must be to induce the public servant to do any act or to forbear or delay to do any act connected with the exercise of the public functions of that public servant.
An example.
A person threatens a police officer investigating a case, maybe saying they'll harm the officer's family if the officer proceeds with the investigation, or someone threatens a revenue official with physical injury if they do not make a favorable but false entry in land records.
And the punishment for such coercion.
Imprisonment up to 2 years, or a fine, or both.
This section seems vital for safeguarding the independence and integrity of public administration, allowing public servants to do their jobs impartially and fearlessly.
Absolutely. It provides crucial protection for public servants against coercion and intimidation, ensuring they can perform their public functions without being improperly influenced by threats. This is vital for a fair and effective justice system and public administration.
Okay, next. Section 225 BNS deals with threat of injury to induce person to refrain from applying for protection. This seems to protect the right of victims or anyone needing help to actually approach the authorities.
Exactly. This criminalizes threatening a person specifically to deter them from seeking lawful protection from a public servant. The purpose must be to induce that person to refrain or desist from making a legal application for protection against any injury to a public servant who is legally empowered to give that protection, like the police.
So no one can be intimidated into not going to the police or other authorities if they've been harmed or need protection.
That's the goal. For instance, a person is being harassed and wants to complain to the police, but the harasser threatens them with further harm if they dare to go to the police station. Or, after an assault, the assailant threatens the victim with more violence if they file a complaint or cooperate with the investigation. Those threats fall under this section.
And the punishment here?
Imprisonment up to 1 year or a fine or both.
What fundamental right does this protect for citizens?
This safeguards a citizen's fundamental right to approach state authorities, the police, courts, other agencies, for seeking protection and redressal without fear of reprisal. It directly counters attempts to silence victims or complainants through intimidation, aiming to ensure unimpeded access to justice and state protection.
And finally, a very unique and frankly quite disturbing provision, Section 226 BNS, which deals with attempt to commit suicide to compel or restrain exercise of lawful power. This seems to criminalize a suicide attempt, but only in very specific manipulative circumstances.
This is indeed a unique and sensitive offense. It penalizes an attempt to commit suicide only when it is done with the specific intent to compel or restrain a public servant from discharging their lawful official duty.
But wait, wasn't attempted suicide largely decriminalized in India by the Mental Health Care Act 2017? How does this section fit into that legal landscape?
That's the absolutely critical nuance and a crucial distinction to make. This section does not criminalize all suicide attempts, and it must be read in light of the Mental Health Care Act, which presumes immense stress underlying suicide attempts and generally decriminalizes the act itself.
So this isn't bringing back criminalization of suicide attempts generally?
No. Section 226 only criminalizes the attempt when it is demonstrably used as a manipulative tool, as a form of coercion or blackmail, directed specifically at a public servant to influence their official actions. The specific, clear purpose must be to compel or restrain the public servant's discharge of duty.
Can you give an example of this very specific scenario?
Imagine a person facing lawful eviction by municipal authorities. If they attempt to self-immolate at the scene with the clearly declared intent of forcing the officials to stop the demolition using the suicide attempt as leverage that could potentially fall under this section.
Okay.
Or perhaps an individual under arrest attempts suicide while in a police station, explicitly stating they are doing it to compel the police to release them. The intent to coerce the official action is key.
And the punishment for this complex and sensitive offense, it includes community service again.
Yes. The punishment is simple imprisonment up to 1 year, or a fine, or both, or community service. The inclusion of community service here, again, seems like a modern and potentially more compassionate approach, recognizing the likely distress underlying such acts, even when they are deemed manipulatively intended by the law, while still addressing the coercive aspect aimed at the public servant.
What's the complex implication of this provision? What is it trying to achieve?
This section aims to prevent individuals from using the extreme act of a suicide attempt specifically to blackmail or unduly influence public officials in the performance of their duties. It seeks to protect the integrity of public administration from such highly coercive tactics. It's undoubtedly a complex provision, attempting to balance considerations of human desperation and mental health with the need to prevent the abuse of such a grave act for coercing lawful authority. It really highlights the nuanced and modern challenges the law seeks to address. #outro.
Wow, what an extensive journey that was through some really critical sections of the Bhartiya Nyaya Sanhita 2023.
It certainly covers a lot of vital ground.
We've truly uncovered the intricate legal framework designed not just to punish after the fact, but seemingly to proactively maintain public tranquility, ensure the unwavering integrity of public servants, and uphold the bedrock principles of our justice system.
From those nuanced definitions of unlawful assemblies and the serious consequences of rioting and hate speech,
Right, through to the stringent accountability placed on public servants for their actions or inactions.
and the myriad ways citizens are expected to cooperate with lawful authority, telling the truth, showing up, not obstructing. It's all part of a system designed for a structured, fair, and orderly society.
Exactly. And these aren't just abstract legal texts for lawyers and judges, are they?
No, absolutely not. They're the very rules that govern your safety in public spaces, the level of trust you can reasonably place in government officials, and the fundamental expectations of truth and cooperation that allow our complex society to function day to day.
They really reflect our collective aspiration, perhaps, for a just and harmonious community, giving us clearer guidelines for expected behavior and accountability in a truly modern context. So, as these new laws become the guiding principles of our justice system, maybe the final thought for you, our listener, is this. How might our collective understanding of civic duty, individual accountability, and the proper functioning of authority evolve under this new code?
That's a great question. And what new responsibilities do these granular legal distinctions, like knowing when an assembly becomes unlawful, or the duty to report certain things, or not misleading officials, place on each of us?
It seems it's not just about avoiding breaking the law anymore, but perhaps actively contributing to upholding public trust and order.
It certainly is just a more active role for the citizen in some respects. It's a reflection, maybe, of the kind of society we collectively build through our actions and our understanding of the law.
Something definitely worth thinking about. Thanks for joining us on this deep dive.